Well, hello everyone. Today is September 19th, 2024, and today's seminar or webinar in our ongoing church law series is You've Been Called to Testify, Now What? And this is provided on September 19th, 2024. It's an attempt to be accurate as of this date, and we're going to talk about a few scenarios and how to prepare for testifying in court in Arizona. So let's go through a few of the scenarios where a church leader might be caught in what I call the vortex. So the first one is I don't need to call attention to it. That's certainly true. The criminal scenario where a church leader might be a witness to a crime. This doesn't happen very often. I have not been witness to very many crimes in my life where I'm walking down the street and someone is a victim of a crime and the police come to me and say, I need your name and phone number. You're going to be a witness to a crime. In fact, in my entire life, this has never happened to me, but it could happen. And it could happen at church, could happen in the church parking lot, and a church leader, pastor, or a lay leader could end up in court in the witness stand because the church leader is a witness to a crime. So we can't avoid this possible scenario where the question will be, what did you see? And is the person that assaulted the victim here in the courtroom today? Can you point this person out? A classic television or movie situation where you're on the witness stand and the question is, can you point out the person in the courtroom here today? And that would be a scenario where you would be called to testify. Not really the focus of today's discussion, but it could happen. Another one that can happen, and I've thought about this presentation today through the stories told by my father-in-law, a senior pastor over 55 years of ministry, and some of the stories that I've heard from him. Passed away 5 years ago. He testified at times as a character reference at sentencing hearings. And so this could happen where someone that the church leader or pastor has come to know over the years in ministry gets in trouble. And at the sentencing hearing, the attempt is to testify to the character of the sometimes we call the person the citizen accused, and the plea is for leniency from the family, and there might be a letter or testimony at sentencing, and who better than the pastor to come testify or write a letter to the character of the accused at sentencing. This could happen. There might also be a parole hearing. Someone's been in prison for some period of time. There could be someone who has a youthful indiscretion, DUI or something like that, and there was someone died, and they have been in prison for their entire youth. And the family of this person who had a DUI and spent their entire 20s and half of their 30s in prison wants you as a church leader to go to the parole hearing and say um, whatever you can to help this person be released from prison early on good behavior and be released from prison on parole. This could happen. And no criticism whatsoever. My father-in-law certainly ended up in this situation from time to time, and with with good conclusions and good character, and with a well-meaning heart. So I have no criticism at all. of either of these second and third bullet points on the screen. Absolutely. It can also happen in what we call family law. Different states have different terms for domestic relations, family law. Essentially, we're talking about divorce, child custody, and all things related to a marriage and child custody, and all of the legal issues that are related to that. So don't get too confused about how we refer to it, but all court cases having to do with disputes of the family, marriage, child custody, and the dissolution of marriage is essentially what I'm talking about. You could be caught in the vortex of a dispute, a fight about child custody. It's not what it used to be in a sense. There are these situations, and perhaps you have been part of it when you were a kid, or this happened to you, or you know someone where it happened to you. There are these situations where, in the old days, a judge might ask a kid of age 12 to 15, hey, Johnny, do you want to live with your mom or do you want to live with your dad? And that was sometimes how child custody decisions were made in court. Now, this was traumatic for the child, of course. And when I was in law school, this was discussed by my family law professors. And the standard for making child custody decisions under the law is supposed to be the best interest of the child. But for many years, the default position for child custody was to live with the mother. And there's been a revisitation of that. And now one of the default positions is equal custody, 1 week with the mother, 1 week with the father. The jury is still out. That's a euphemism for people are still trying to decide if that's good either. Close at mom's, close at dad's, kind of go back and forth. They have to basically live in the same neighborhood for this to work. And today's discussion is not really about that. But a pastor or a church leader could be brought into the vortex of a child custody dispute, not necessarily on the question of who's better to parent the kids, but a kidnapping issue, or what's going on with the church. We've had situations that I've dealt with as a church lawyer where the church is caught in a non-custodial parent on campus trying to take the kids on a non-custody week or a non-custody weekend. And now the church leader has to testify about that incident on that weekend. And this is an uncomfortable situation for the church, of course, when the church should have adequate and sufficient protocols for dropping off kids and picking up kids. It's not the drop off that's the problem, it's the pickup that's the issue. And the church needs to only hand a kid back to a parent who presents adequate identification that's consistent with the drop off protocol. So if you have a drop off protocol that is some kind of QR code or some other kind of ID system, so that the parent who dropped the kid off receives the kid back, then that's what needs to happen. But we end up in situations sometimes, I see we in the collective sense, the church world, where a non-custodial parent dropped the kids off the prior week. And so the volunteer workers know the dad. It's always the dad, of course. They know the dad from the prior week. And so the next week, the dad comes to pick the kids up, but it's not the dad's custodial week. And so they give the kids to the dad, even though the dad didn't drop them off that week. And now that becomes a major dispute between the mom and the dad, and it ends up in court. And the church leader gets called to testify about that incident. That's a way that a church leader can end up in the vortex of testifying in court. So we can avoid that by having tight child custody at church protocols, drop off and pick up protocols in our childcare situations, which I've talked about before and we'll talk about again in this series. We also, in the family law context, we have injunctions against harassment. The injunction against harassment is a legal remedy that was invented because men, it's always the men, were doing things that were technically legal. It's kind of like the kid who, it's always the boys, harassing his sister, and the sister says to the parent, Bobby's bothering me. That's the brother's name. Bobby's bothering me. And Bobby says, I'm not touching you. Well, technically, that's true. So what men were doing is they were placing hundreds of phone calls to their ex-girlfriends or following them around the grocery store. And the ex-girlfriend would call the police, and the police would say, it's not against the law to place phone calls. Or the police would say, it's not against the law to go to the grocery store. Well, these were all technically true statements, but the women were saying, I feel harassed and bothered. And so the women correctly went to the state legislatures around the country and said, this behavior is intended to drive me crazy. It is engineered to harass me. And so the legislatures correctly responded and invented, through the statutory scheme, an injunction against harassment procedure where the women could go to the court and get an injunction, a court order to stop the harassing behavior. So the woman only has to go to the court, fill out an affidavit, and get an injunction that says, stop the harassing behavior. It's served then, after the judge signs it, on the ex-boyfriend. It's entered into a database. And then when the ex-girlfriend calls the police, it's in the computer, it's on the laptop in the cruiser. And then the ex-boyfriend is now able to be taken to jail. And sometimes in those situations, and it's the injunction says the ex-boyfriend can't come within 100 feet of the ex-girlfriend. I'm using that as an example, but it could be ex-wife or ex-husband or whatever. It includes church. And so those incidents can happen where the ex-girlfriend or ex-wife is worshiping on Saturday evening or Sunday morning, and the ex-boyfriend shows up, and the ex-girlfriend calls the police from her cell phone in the pew, and the police show up on campus and arrest him. And it's of course very dramatic, and the congregation wide-eyed and rubbernecks the whole situation. It's the most dramatic thing that's happened on campus since the Easter sermon, if we want to say it that way. And there could be a hearing in court over this, and it's entirely possible that at the hearing or trial that someone at the church could be called to testify. And so these things can happen. They don't happen every week, thankfully. But this is another scenario where we could end up in court as a witness. Now, as it turns out, the ex-boyfriend's mere presence on campus within 100 feet of the ex-girlfriend, that's the violation. The so proving that by the police showing up and arresting him, the factual necessity to have a church leader testify is not that important. So the facts are there by the mere presence of the boyfriend. If I were the lawyer involved, I'm not sure I would need the church leader to testify, but every once in a while, lawyers get involved and they think, well, if I can get the facts into evidence with one person, having three people say the same thing would certainly be better. I can make my point in triplicate. If I can make it one time, it's better to say the same thing 3 times. I don't believe that. If I can say it once and prove it once, that's good enough. And most judges think, don't say the same thing 3 times. Once is enough. Here's one of the things we run into in family law when church leaders get pulled into the vortex. Whoever is calling the church leader develops the expectation that the church leader is going to take their side and testify through the lens of advocacy. And this can be difficult and troubling as a church leader. I'm a lawyer. I've been a lawyer for a long time. I served as an elder at my church in the 90s. At my church. But this is where it becomes very problematic. The scenario is that there's a divorce that's going on. It's contested, it's the hypothetical, and the wife in the scenario is telling the story that it's terrible, it's the worst. To hear her tell the story, it's the worst divorce one could ever imagine. He's the worst. He's been terrible, terrible, terrible. And your testimony as a church leader is the difference maker for this divorce to be okay, and for her life to be okay. Well, the problem is that when a church leader testifies in court, testimony is what we call in the legal process or fact finding. It's to establish facts, FACTS. And judges decide the law, and testimony is for facts. The advocacy is for the lawyers. Lawyers are advocates. Lawyers urge the judge to see the law a particular way, and they urge the judge to see the facts a certain way in light of the law. So when a party to a lawsuit expects a witness who's testifying to facts to be an advocate, it's a trap, frankly. Hey, pastor, will you testify in my family law matter? And don't forget that my soon-to-be ex-husband is terrible, terrible, terrible. Well, okay, I understand you're saying that, but here are the facts as I understand them. And I can testify to the facts as I know the facts to be from what I have seen with my eyes, what I know to be true. Anything beyond that, I can't speak to, because I can only speak the truth, which we'll get to in a moment. So criminal can come up every once in a while, but the same thing, what you've witnessed with your own eyes and you've witnessed from your own experience, and then family law, But the caution with family law is know your role. You're testifying, but you're not an advocate. And then we have this scenario where child sexual abuse and mandatory reporting. On my website, in inventory of a past seminar, we have mandatory reporting of sex crimes and other victimization. This can come up when you are aware that a child has been a victim of a reportable offense. And this can happen when the church is in a position where it's a mandatory reporter. Well, if you have a reasonable belief regarding a minor who's been victimized by a reportable offense, we may have a mandatory duty to report. If that's the case, you're going to end up testifying in a criminal proceeding, most likely. And a failure to report, when you have a mandatory duty to report, you may be charged criminally. And the sex crimes detectives and prosecutors are not reluctant. They are not reluctant to charge church leaders for failure to report. In fact, they're looking for it. They take it extremely seriously, as they should. And then every once in a while, as part of civil cases, family law in particular, the participants may want to take a civil deposition, basically testimony under oath in a law firm conference room to flesh out the facts before trial. But it's really the same thing. It's testifying under oath with a court reporter taking down every word to get to the truth of what the facts are, the facts of what happened, and the facts of what you know as a witness before it goes to trial. And it can be it's just as important, and it's just as tricky. So these are the scenarios where church leaders can be caught in the vortex. Now back to my father-in-law, 55 years of senior pastor ministry over his life. I remember all of these from his stories that he had told me over the years, that I was his son-in-law before he passed. But I don't remember very many civil deposition stories. Maybe that's from my law practice that I'm creating that. So I'll concede the point. All right, so here's the required legal response. Arizona Rule of Evidence 603. Here's what it says verbatim. The title is Oath or Affirmation to Testify Truthfully. Every witness must give an oath or affirmation to testify truthfully in a form designed to impress that duty on the witness's conscience. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? So the so help you God part is not in the rule of evidence itself. That's not right here. I mean, this is verbatim from the actual, what we call black letter law of what the oath is that's required for a witness to testify in court. And so this is it. The witness must give an oath to testify truthfully in whatever form is designed to impress that duty on the witness's conscience. So each judge in that courtroom creates the form of the oath designed to impress that duty on the witness's conscience. Rule of Evidence 603. There's lots of rules of evidence And this one is the one that says you have to testify truthfully. Now, I did not, I made a decision not to um, provide a scriptural mandate for telling the truth. I think that's pretty much implied, but I could have. But I decided not to go back to my Wheaton College education and do all that research. But as church leaders, I don't think there's any debate that we have a biblical mandate to tell the truth as Christ followers. No scriptures mandate or excuse lying under oath. So that's my nod to our mandate as Christ followers. All right, so what is perjury? We know it, that there's a consequence under the law for lying under oath. Here's what it says. A person commits perjury by making either a false sworn statement. Again, remember, we're swearing here to tell the truth. A false sworn statement in regard to a material issue, believing it to be false. So you have to know it's false, or alternatively, a false unsworn declaration or statement in regard to a material issue that the person subscribes as true. So you're saying it's true under penalty of perjury, believing it to be false. You have to know it's false. And it's a class 4 felony. So we're taking this seriously. You have to tell the truth. So how do we prepare for trial? Well, we do this whiteboard arrows exercise, and it can be done in the abstract. We don't actually have to stand in front of a whiteboard, and it doesn't have to be done by a lawyer, although it can be done as a legal exercise. And here's what we do. Essentially, what it means is we ask the hypothetical question: will the church get in trouble if we decline to be involved? If the church says to this divorcing family, we don't want to be involved in this case, we're not involved, and we don't want to testify in your divorce dispute. What's the potential liability and ramifications for the church? What will happen? Well, in some cases, what will happen is you will be on the receiving end of a subpoena, and you will be compelled to testify. Okay, then you'll show up and tell the truth. No problem. But as it turns out, in many cases, like that one, they're asking you to voluntarily participate. And you could decline, and there would be no consequence. In other cases, a mandatory duty to report, it's not optional. And if you decline or think you can decline, you might be criminally prosecuted. In the situation where a parishioner, a member of the church, is in prison and the family's asking you to help with the parole hearing, you can decline to be involved, and the family will simply be frustrated with you. Okay, But maybe it's okay to help, and maybe it's not that big a deal. Maybe you do want to help. Maybe that's the gracious and graceful thing to do. Uh, so this whiteboard arrow exercise is essentially drawing circles and squares on a whiteboard, and the arrows basically are what if questions. What if we do? What if we don't? And are there liability consequences if we do? Are there liability consequences if we don't? And like I said, a lawyer can help. A lawyer isn't necessarily necessary, because some of the answers are pretty obvious. It doesn't always take a lawyer to ask the question, um, can we get in any trouble if we help? Can we get in any trouble if we don't? And sometimes the questions, it's a 5-minute phone call. You just give me a call and say, somebody wants us to get involved in this legal thing. My inclination is I really don't want to do it. Quick story. When I was a teenager, my younger sister, 2 years younger than me, witnessed a car accident. And my younger sister, she's probably 15 at the time, gave her name and number to the people involved. And my dad, who didn't know I was going to eventually be a lawyer, of course, I was probably 17 at the time, got a phone call from somebody involved in the accident. And he told me he was quite upset about it. He essentially said, there is no way I am letting your sister get involved in being a witness to some car accident. He was very upset about it. Now, I have 3 daughters. They're all married and adults now. And I was really surprised at how upset he was, because I was 17. I thought I was really important and an adult, and I thought I had everything under control, and I was driving, and I thought I had it all together. Of course, I didn't. Looking back, I didn't at all. But he was so upset at the idea that my younger sister was going to be pulled into the vortex of being a witness to a car accident, a very adult thing in his mind, I guess. And he just put his foot down and said, there is no way that your sister is going to be a witness to a car accident. And I guess there's always that option, that when you consider the whiteboard arrows exercise, you can always do a Dan Carpenter, that's my dad's name, and say, there is no way that we are going to be a witness to that car accident. And so, but for reasons that I still don't fully appreciate, for just for the hassle factor, which is kind of what that was. So these are the questions. Can the testimony impact the church? But this is the most important thing that I want to get across today, which is the need to absolutely commit in advance to telling the absolute truth, no matter how it feels, no matter how it lands, and who it lands on. I mentioned my 3 daughters. One of the principles that was important to me as I raised my daughters, and if they were here today, they would laugh at what I'm about to say. I told them when they were old enough to understand it, never lie, but in particular, never lie to your doctor and never lie to your lawyer. So we could add to that and say, never lie to your doctor, never lie to your lawyer, and never lie on the witness stand. So that's what this is. Never lie, tell the absolute truth, no matter how it feels, no matter how it lands and who it lands on. That's what we're doing here. If the truth is that in telling the truth in court, your best friend's marriage will end by telling the truth, tell the truth. If by telling the truth, you will cry on the witness stand in open court, you have to tell the truth. If by telling the truth, your spouse will be mad at you, you have to tell the truth. And these things happen. These things happen in court. If by telling the truth, your child will be angry with you, you have to tell the truth. And if by telling the truth, your parent will be angry with you, you have to tell the truth. This is what happens in church work. And it kind of all goes back to that notion from a couple of slides ago that in court, there are times when people don't fully appreciate that when you're testifying, it's about the facts. It's not about advocacy. You cannot take the witness stand to be an advocate. You are taking the witness stand to say the traffic light was green or the traffic light was red, not about anything else. It's not about, I think my friend is a good parent. It's my friend was there at 3 o'clock to pick up the kids and the kids were not there. That's a fact. My friend tries to be a good parent. He tries to get there at 3 o'clock. No, the question was he there at 3 o'clock? Not whether he's a good parent or not. So this is the most important thing when you're testifying, is to commit to tell the truth in advance, no matter how it lands or who it lands on, and no matter how it's going to make you feel or what it's going to mean to the people in your life or how it's going to feel to anybody else. It's the most important part of testifying in court. And for some people, it's why they don't want to do it, because they don't know who's going to be in the courtroom and they don't know how it's going to land, but can't be part of the consideration. It's just the way it has to be. Now, there are times when people say, well, I really want a lawyer to help me. I had a case this week where someone is in the middle of their parents' divorce. The mother subpoenaed her own son to testify at a divorce trial. And he wanted me to go to the trial with him. And I said, well, I could go with you, but I can't sit at the tables. I'd have to sit in the back of the courtroom. But I can't object. I can't sit at the tables and object to their questions because you're not a party to the case. So it's actually very difficult to represent someone who's been called as a witness. Because I'm in the back of the courtroom, you're on the witness stand, but you're not a party. I could object in my mind to a question, but you're there to testify to facts. Not a fax machine, but FACTS. It's hard to say that sometimes. So I can drive you there. We could talk about it on the way, but you've been subpoenaed. I don't know how to protect you during the testimony. There's no way to really do it. So I can't protect you. We could prepare by saying always commit to telling the truth in your parents' divorce, and they're going to be sitting at the tables, but these 5 bullet points here at the end, you have to really commit to that. So that's where we end up in the you've been called to testify. Now what is really this part right here. And when he's testifying, because he's been subpoenaed, he has to show up. It'll be hard for him. Parents are battling. They've subpoenaed their own kid, adult child, to testify in their divorce trial. Can you imagine? No matter what the truth is, no matter where it lands, even if your parent is going to be angry with you, you have to tell the truth. Unfortunate. All right, in a webinar, the questions end up in the chat. Happy to take a few of those. If there aren't any, please join us for the next one. And all of the seminars I've done all year are on the website under seminars. And the ones I've done are down below under completed, I think is how it's done there, but the ones coming up are at the top and the ones I've completed are down below. Well, thank you for joining me. Hopefully you've enjoyed this and giving you some tools to prepare if you ever get called to testify in court. Thanks, everyone, and hopefully you'll join me in our continuing series of legal issues affecting Arizona churches. Thank you.